Have you been thinking about writing a last will and testament? Well, if you have, this basic estate planning guide could be very, very helpful to you. I'm attorney Vernita Williams. This is a basic estate planning guide that will help you understand some very simple things you need to consider before you meet with your attorney. Now, whenever people call me and say, I want to write a will, I always share with them that you need to do planning in two specific areas. Those two areas are incapacity planning and estate planning. Now, estate planning normally entails writing a last will and testament, but it's good to do planning in both of the areas. Do you know why? Well, documents in one of the areas will not work for the other area. For instance, the incapacity planning area will provide documents that you use if you are alive but incapacitated. The estate planning documents are documents for use if you have passed away and you would like to advise your executor what you want them to carry out as far as estate administration. Now, if you have just incapacity documents such as a durable power of attorney, that document will not work if you've passed away. One of the key things you need to understand is if you have a power of attorney, it's not going to be good once the person that gave it to you passes away. So, in your planning, you need to do incapacity planning. That's the first area. And you need to do estate planning. That is the second area in which you will normally do a last will and testament or other things. So now, in this part one of the presentation, I'm just going to specifically talk about what you should do if you are doing incapacity planning. The incapacity planning documents normally consist of a living will, a medical power of attorney, and a durable power of attorney. Now, the living will is not the same thing as the last will and testament. Many times people will come to my office and they say, I want to do a living will, when they really mean they want to do a last will and testament. A living will is a document which states whether you want to be on life support. That is what a living will is. A last will and testament states who will get your assets if you pass away. So those two documents are very, very different. Under incapacity planning, which is what I'm discussing in this part one of this video presentation, the living will is an incapacity planning document. It states if I'm terminally ill, if I'm not considered to be able to recover, here is what I want you to know about whether I want to be on life support. Now, that living will is often called advanced directive. So many times if you're in a hospital, they will refer to the living will as an advanced directive. Now, the other document, I'm discussing three documents under incapacity planning, is the medical power of attorney. A medical power of attorney designates a specific person, and sometimes it's two people, that you would indicate should talk to your healthcare providers about your care. Now, sometimes people will designate a spouse, and sometimes not. It is not a requirement that your spouse has to have medical power of attorney. But it's extremely important that you designate the person that is going to be responsible, the person that is going to be discreet, and someone that you think is capable of handling medical emergencies if you should have one. Sometimes I have clients with, let's say, 5 children, and they will say, well, this child may be the oldest, but this is not the child that can handle a medical emergency or talking to a doctor about a terminal illness if that's the case. So that second document is the medical power of attorney. The third document is a durable power of attorney. Now, sometimes this is referred to as a financial power of attorney because the document will normally give the person you designate the authority to handle your business and financial matters. This is an extremely important document because this durable power of attorney will keep you from having to establish a guardianship if you are unable to handle your own affairs. Many times people will contact me and say, I need to get power of attorney for my mom or for my aunt or uncle or sister or brother. And a lot of times by the time they contact me, the person has lost the mental capacity to be able to sign a durable power of attorney and give somebody authority to help them. If that has happened, then there will be a guardianship that's necessary. And in most instances, the guardianship is going to be expensive, it's going to be long and drawn out, it will be frustrating because, at least at the beginning, until the guardian figures out what to do, there's going to be paperwork and physician's reports and financial accountings and things that they will have to learn how to do. So you can save yourself a lot of trouble if you go ahead and do a durable power of attorney so that your loved ones don't have to establish a guardianship to be able to take care of you. So under incapacity planning, we have three things. We have the living will, which states whether you want to be on life support. We have the medical power of attorney, in which you designate who will speak to your health care providers. And there is the third document, the durable power of attorney, which will give somebody the authority to handle your affairs if you cannot. So those things fit under incapacity planning. They do not take the place of estate planning. In fact, they are null and void once you pass away. So that's why it's extremely important to do planning in both of the areas, incapacity planning and estate planning. So if you would like additional information, please go to my website at vcwlaw.com. That is vcwlaw.com. There you can get a free download of 25 things you should do to set your affairs in order. If you would like to call us with comments, questions, or suggestions, please call us at 786-831-9483. That is 786-831-9483. This has been a VCW Law presentation. This is part 1 of the Basic Estate Planning Guide. Please go to my YouTube channel. There you can find part 2 of the Basic Estate Planning Guide. And in part 2, I'm going to talk about estate planning and the basic things that you need to know in the estate planning area. Thank you so much for listening.